Back, what are the broader ramifications of taking former President Trump off the ballot in Colorado? And is this justified from a legal perspective? Joining us now to explore, we have Mike Davis, founder and president of Article 3 Project. He is the former chief counsel for nominations to Senate Judiciary Chairman Chuck Grassley and former law clerk for Supreme Court Justice Neil Gorsuch. He also practices law in Colorado. Mike Davis, thank you so much for joining us. Great to have you back on the show.
Thank you for having me.
To begin, Colorado has removed Trump from the 2024 ballot, invoking Section 3 of the Constitution's 14th Amendment. Where is the due process here?
Well, this is a completely incorrect reading of Section 3 of the 14th Amendment by four partisan left-wing judges on the Colorado Supreme Court. The case law is very clear. If you want to disqualify someone under Section 3 of the 14th Amendment passed after the Civil War to chase out of office Confederate sympathizers who engaged in insurrection or rebellion against the United States, Congress has to pass a federal criminal statute, which Congress did in 1869, related to insurrection or rebellion. You have to bring federal charges approved by a federal grand jury. You have to have a federal jury unanimously find the defendant guilty with evidence beyond a reasonable doubt. The federal judge has to convict that defendant, and that conviction has to be upheld on appeal through the federal courts. That is the only way you can disqualify under Section 3 of the 14th Amendment. There is a case from Chief Justice Samuel Chase more than 150 years ago that is directly on point. It is controlling, and the Colorado Supreme Court ignored this and railroaded President Trump.
And given the Colorado court's ruling, what are the broader ramifications here?
Well, the Supreme Court needs to decide whether to take this case. It should take this case because this has broader ramifications, as you said, because Trump's not going to win Colorado in the general election. But what's going to happen is you're going to have key swing states try to use this precedent in Colorado to disqualify President Trump in places like Michigan and New Hampshire and Minnesota, maybe Wisconsin, states where Trump is going to win. They know these Democrats, whether they're the judges, whether they're the prosecutors, whether they're the lawyers, they know that President Trump is on the path to beating President Biden like a drum on November 5th, 2024, after the Democrats impeached Trump twice for nonsense, indicted him 4 times for non-crimes, illegally gagged him twice, tried to bankrupt his business for non-fraud, and now this is their legal Hail Mary to simply take Trump off the ballot because they know the American people want to put Trump in the White House.
In terms of the U.S. Supreme Court, if they take up the case, a former Trump lawyer, Ty Cobb, is saying that if the Supreme Court picks it up, it would rule 9-0 on the case. Do you agree with his assessment? Well,
it should be 9-0 for Trump because this case is so easy and there's controlling precedent that you can't just have 4 radical judges on a state Supreme Court like Colorado or a radical Secretary of State somewhere decide on behalf of millions of voters in their state who's going to be on their ballot. That is not how Section 3 of the Constitution works. It's not how it was ever intended, and that's not what Congress wanted when it passed the federal criminal statute. So the Supreme Court should take this. They should reverse this 9-0. Unfortunately, the 3 Democrat-appointed justices on the Supreme Court tend to be political actors, and so this could be 6-3. Who knows if these Republican justices, who oftentimes go weak and wobbly, sometimes you have to wonder where they're going to turn out. This should be 9-0. This is a very easy case.
Now, there's also been growing calls that if the Supreme Court picks it up, Justice Clarence Thomas should recuse himself due to his wife's connections to the Trump White House before January 6th. What do you make of those calls?
That is completely nonsense. It's legally baseless. Judges don't own their wives, right? And Jenny Thomas has been a political activist long before she met Clarence Thomas, long before Clarence Thomas became a judge, and long before Clarence Thomas was elevated to the Supreme Court. The Senate confirmed Clarence Thomas, knowing that Jenny Thomas is a political activist, and that is not the legal standard. If it were the legal standard to recuse someone based upon their wife's political activities, then Biden's special counsel, Jack Smith, would have to step down because his wife is a political activist. She's a Democrat donor, including to Obama and Biden. She produced a documentary for Michelle Obama, but that's not the legal standard, and the Democrats are playing games here.
Now, zooming in on Colorado, there has been pushback within the state where Colorado's Republican Party is saying that if this ruling stays, they're going to make sure that they're not on the ballot completely and convert the system to a caucus. How feasible is that, changing it from a primary to a caucus? Well,
this shouldn't have to happen. And even 3 of the 7 Democrat-appointed justices said that this should not have happened. Three of the Democrat justices filed strong dissents saying what 4 of their radical Democrat colleagues did was un-American. It's unconstitutional. It violates due process. It's unprecedented. It uproots the norms. It's actually a danger to democracy that these 4 radicals are pretending to protect.
Mike Davis, thank you so much for your time.
Thank you.